Hey, what's up, folks? Will Chamberlain, Editor-in-Chief of Human Events here. I just did a very lengthy Periscope on the subject of Michael Flynn's case and the new revelations that Judge Sullivan is going to appoint John Gleeson as an amicus and wonders whether Flynn committed perjury. Check that out and enjoy. And again, if you haven't yet, please do hit that subscribe, youtube.com/human events, and hit that subscribe button right there, and we really do appreciate it. The news today. Washington Post reports that Judge Sullivan has asked a retired judge to oppose the Justice Department's effort to drop the Michael Flynn case and examine if the ex-Trump advisor committed perjury. Here is the order issued this afternoon. It says, and we're going to spend a lot of time on parsing this and what it means and the various citations, and that's what this Periscope will be about. What is Judge Sullivan doing? So, it's an order appointing amicus curiae. Upon consideration of the entire record in this case, it is hereby ordered that the court exercises its inherent authority to appoint the Honorable John Gleeson, retired, as amicus curiae to present arguments in opposition to the government's motion to dismiss, citing Fokker Services and Gin v. Ministry of State Security. And it is further ordered that amicus curiae shall address whether the court should issue an order to show cause why Mr. Flynn should not be held in criminal contempt for perjury pursuant to 18 U.S.C. 401, Federal Rule of Criminal Procedure 42, the court's inherent authority, and any other applicable statutes, rules, or controlling law. So lots to parse here, but we're going to start. Let's start at the very beginning. Who is John Gleeson? All right, who is this guy? Okay. John Gleeson is a lawyer at Debevoise and Plimpton, a big law firm, a very, very prestigious law firm, one of the it's usually ranked in the top 10 most prestigious law firms in the country. But in particular, Gleeson is a very, very prestigious and credentialed guy. He was a federal judge for 22 years before he retired in 2016. He was both a district court judge, and he also did some appellate decisions, because that sometimes happens where district court judges are brought in to kind of, pinch hit on an appeals panel. He was in the Eastern District of New York. He authored more than 1,500 published opinions, including 14 opinions for the United States Court of Appeals for the Second Circuit. Presided over more than 200 trials, and assigned multi-district litigations, which are incredibly complex. And so this is a guy with a very, very extensive experience and a very, very serious person. Why was he selected? Well, Mr. Gleeson wrote an op-ed 2 days ago saying that the case isn't over until the judge says it's over. And so we'll kind of go through some of his logic. This will preview some of the stuff we'll be discussing. The Justice Department's move to dismiss the prosecution doesn't need to be end of the case, and in Gleeson's view should not be. He says it's just a request that requires leave of the court. While the executive branch has the authority to decide whether to prosecute, the judge has to give permission. That's what's being said here. This is a little bit sketchy, given we'll see what's going on with D.C. Circuit Authority, but it's a little bit sketchy. He talks about how prosecutors deserve a presumption of regularity, but corruption would detract from that. There's been nothing regular about the Flynn case. That the department's idea that it couldn't prove the case is belied by the fact that Flynn admitted that he had his guilt in court and pled. But this is the key part. This is where Gleeson's talking about what could Judge Sullivan do in his view. So Gleeson argues that the court could require the career prosecutor to explain why they stepped off the case. I think that's probably true. You can bring, courts can bring people before and be like, explain yourself. Like that can happen in situations like this. It can appoint an independent attorney to act as a friend of the court, ensuring a full adversarial inquiry. Funny enough, Judge Sullivan apparently read that and was like, good idea, you can be the guy. It can force him to reveal the actual evidence underlying the prosecution. That's a little bit more sketchy because that evidence is a classified NSA transcript, so it's not, I don't know that, I would need to see the law that suggests that Sullivan has the authority to do that on his own, and that would be lawful. So somebody said, it says here, Flynn's guilt has already been adjudicated, so if the court finds dismissal would result in a miscarriage of justice, it can deny the motion, refuse to permit the withdrawal of the guilty plea, and proceed to sentencing. I don't think that's true, and we'll get into why in a moment. But so this is what Gleeson thought, so Gleeson was appointed amici. Why? So let's go back to Judge Sullivan's order here. Okay. Judge Sullivan has said Gleeson's the amici, and he cites two cases for that he wants that he's here, and they have sort of different functions. One is this case, Ginn versus the Ministry of State Security. This case, as far as I can tell, is just about the legal standard for filing amicus curiae briefs. You see Ginn. This talks about how district courts have the inherent authority to appoint or deny amici, derived from Rule 29 of the Rules of Appellate Procedure. Basically, like there's a lot of discretion that a judge has to appoint an amici to take a particular position. So, and I know that there's some people who've been saying, "Whoa, you got to worry about abuse of discretion." There was a Supreme Court case, and there was recently a Supreme Court case that dealt with the abuses of courts using amici to present certain positions. This case, Sinanang Smith, which was decided on May 7th, just a few days ago, actually. Justin Ginsburg, a unanimous opinion from Justice Ginsburg. So the entire court rejected what happened here. But once you understand what happened, it's kind of crazy. So this is basically a normal appeal where somebody is being prosecuted for an immigration crime. And what ends up happening is that the Ninth Circuit decides to use amici to like completely take over the case. So, right here, it's starting from here. You'll have to forgive that you won't understand the full factual context of the case, but we want to get to the point here. The appeal to the Ninth Circuit commenced unremarkably on brief and oral argument. She reasserted her arguments before that she talked about in her motion to dismiss and her motion for acquittal. Here's the key point. With the appeal poised for decision based on the parties' presentations, the appeals panel intervened. It ordered further briefing, but not from the parties. Instead, it named three organizations: the Federal Defender Organizations of the Ninth Circuit, the Immigrant Defense Project, and the National Immigration Project of the National Lawyers Guild. I just want to say that the National Lawyers Guild are the people who were protecting weather underground terrorists in the 1970s. These are straight, hardcore leftist activists. And the Ninth Circuit was like, hey guys, come in here and help us with this case. Really, really appalling. And invited them to brief three issues that were completely different from the stuff that was being talked about in that case. And eventually, basically, the defendant in that case came along and was like, hey, I guess the panel really wants us to argue that the statute's unconstitutional. We should argue that too. Ultimately, basically, the Supreme Court was like, this is a takeover of the appeal. You should rely on party presentation. Normally, this was not a situation where amici were called for, and certainly you shouldn't have let amici hijack the entire proceeding. I don't think that argument will fly in this case. Basically, a classic situation in which an amici is called for, in which there is a position that has been effectively abandoned by one side, maybe the government or maybe one of the parties to litigation, but that's a position that the judge still wants to hear out, and therefore the judge will appoint an amici to defend that position. That's fairly common and happens at the Supreme Court in some cases. Like, for example, it would have happened, I'm not sure if it happened, but for example, when the United States refused to defend the gay marriage essentially, I think it was Windsor and the gay marriage statute, a court could have appointed an amici to defend a position if the judge wanted to hear argument on it. So basically, amici is not, people who said like, oh, that's bizarre, he should never do this. I'm like, if the judge was thinking maybe I want to hear arguments about whether or not I can dismiss this, it is not unreasonable for him to appoint an amici to have a lawyer come in and present those arguments and try and win them. I mean, that's like, I don't think, I think the judge should just dismiss this case outright. I think the authority is clear, but I'm willing to, if the judge thinks there might be some question, like, I don't think it's absurd to appoint an amici if he thinks there's some questions about it. So that's the amici side. There's also another case cited by Judge Sullivan, is this case, Fokker Services, which I've been talking about. If you've been following the Periscopes for a while, you'll know that I've been talking about this Fokker Services case because it's devastating to the broad notion that the judge can simply refuse to dismiss the indictment, right? Like, he cites to page 740, which is this one, but that it starts by talking about fact situation, but then it goes into all the stuff about how the executive's primacy in charging decisions is long settled. The Supreme Court has emphasized that whether to prosecute rests in the prosecutor's discretion. Judicial authority is at its most limited when reviewing the executive's exercise of discretion. And I mean, that ultimately comes to, it has a specific discussion of 48A, which is obtaining leave of court to dismiss charges, and ultimately says like, the leave of court authority gives no power to district court to deny a prosecutor's Rule 48 motion to dismiss charges based on the disagreement with the prosecution's exercise of charging authority. The only thing it's there for is to guard against prosecutorial harassment of the defendant through repeated attempts to bring charges. So, like, if the prosecutors are going to keep coming back and forth to charge things, that might be a circumstance under which you would see, you know, a judge might question it. But basically, the D.C. Circuit, which has binding authority on Judge Sullivan, is saying, like, you can't dismiss and you can't refuse to dismiss an indictment because you think it's a bad decision, right? And that's where, like, this op-ed, you know, from this esteemed judge, you know, where he, you know, he gets up and he says something like, if the court finds dismissal would result in a miscarriage of justice that can deny the motion, that's just flat wrong under Fokker Services. But understand, like, I'm sorry, under this Fokker Services case. But understand also, like, Judge Sullivan is citing this. Like, he's aware of this case, and he's citing to the exact part where he's like, do I actually have the authority to do this? So my suspicion is that Judge Sullivan currently does not believe he could actually refuse to dismiss this indictment. He's read the case, I've read the case, everybody's read the case, and nobody really thinks he can get away with it. Which is why I think he's proceeded to this second bit, and this is the bit that I found. One of the reasons it took me some time to put this together is I had to, like, try and get a handle on this area of law, and I did a little bit, oddly enough, research on the law of contempt in the United Kingdom. If you guys are really, really OGs, you would remember me doing analysis of the Tobby Robinson cases in England, and the fact that he was charged of contempt of court, and trying to understand exactly what the judge had done there. Anyway, so here's the order that the amicus curiae shall address whether the court should issue an order to show cause. This is all confusing. Basically, this would be, this is like, explain yourself, explain why you aren't in criminal contempt, and for perjury. And then it's pursuant to all these different authorities: 18 U.S.C. 401, Federal Rule of Criminal Procedure 42, and the court's inherent authority, and any other statute. So I want to go through these in order. So first, 18 U.S.C. 401. That's this. That's the power of the court. A court of the United States shall have power to punish by fine or imprisonment at its or both. Oddly enough, there's a case where that language wasn't there, the or both, and somebody got up and said, hey, I paid my fine, they can't imprison me. And the court was like, I guess so. Anyway, fun stories. They fixed that part of the law. It happens a lot. Basically, they can punish by fine or imprisonment the misbehavior of any person in their presence, so near to as to obstruct the administration of justice. This is things like you're in court and you're yelling and screaming, and you won't let the trial continue. They could punish you for contempt. Misbehavior of its officers and their official transactions. So, like, you know, court appointees being bribed, that would be contempt and something the judge could punish on their own. Disobedience or resistance to its lawful writ, process, order, rule, decree, or command. This is where potentially, I think, General Flynn is this is what Judge Sullivan's thinking about. The idea being, certainly a judge has the ability to command the people in front of it to tell the truth, and therefore, and to also to follow the law. When it puts people under oath, they swear to tell the truth. So if they don't, if they lie, I think that probably would constitute a contempt under 4013, arguably. I don't know the answer to this question. Like, I couldn't find a definitive answer about whether a perjury itself could be a contempt charge. So I don't know. But I think my guess is, if I had to guess, yes. I think it seems like that's that. There's also 18 U.S.C. 402. The very next section of the statute, which is contempts constituting crimes, saying that any person who disobeys any lawful writ, process, order, rule, decree, or command of any district court by doing any act therein, if the act or thing would also constitute a criminal offense under any statute. So, like, clearly a perjury offense, right? Perjury is a federal crime. You can't lie to, the court. And to the extent that perjury is a crime, therefore, it would also be, if he's disobeying a court order and it's also a crime, that would be a criminal contempt. This would be a fine of no more than $1,000 and imprisonment of no more than 6 months max. So, oddly enough, under that sort of thing, that would not require a jury trial, because under federal law, as my guess is, it wouldn't require a jury trial, because under constitutional law, crimes with a maximum sentence of 6 months or less do not need a jury trial. So Flynn could convict him of criminal contempt for 6 months without a jury trial. I think that's what I think is happening. But maybe not. Maybe I'm wrong. I forgot about this statute. Oh, sorry, I get things wrong. 18 U.S.C. 3691. Whenever a contempt charge shall consist in disobedience of a rule decree, the accused shall be entitled to a trial by jury. So apparently, that's not, the 6 month rule doesn't apply here. They basically say you're entitled to a trial by jury if this is the contempt. So I was wrong. Oops. I'm a little tired, guys. It's almost 9, I think. The other thing, so that's the 18 U.S.C. 401. Remember, there are three different, grounds. 18 U.S.C. 401, Federal Criminal Procedure 42 is the second one. That basically explains like what procedure. Any person who commits criminal contempt may be punished for that on notice, and then the judge can appoint their own prosecutor. Right, the judge first must ask the government to do it, but I don't think the government would do it in this case because they want to let Flynn go. So the court could appoint a different attorney to prosecute the contempt, like an independent, just like an actual special prosecutor, a lawyer in private practice to come in and prosecute the case. And so would be entitled to a jury trial when federal law so provides. Very likely the trial would, I guess, probably have a jury trial. That's my guess. The third area, this is where some people are accused. They think that Judge Sullivan is acting way beyond, but like understand that the contempt power is actually inherent, right? Like, so if you go back, people are saying the court's inherent authority. I had somebody message me thinking, how is Judge Sullivan beyond his, ken here when he says that? And it's like, actually, no. I mean, this is a very old Supreme Court case, but it's where this was explained, and it actually holds up very well. This is 1873. But it just really clearly explains it. The power to punish for contempt is inherent in all courts. Its existence is essential to the preservation of order in judicial proceedings and to the enforcement of judgments, orders, and writs of the courts, and consequently to the due administration of justice. The moment that the courts of the United States were called into existence, they became possessed of this power. It's limited by Congress, but there is an inherent authority that courts have to enforce contempt. That's normally for people, again, disrupting the courtroom, behaving badly, refusing to testify. That's contempt of court. Like when they've been subpoenaed. Like basically when a court's trying to do justice, it has this inherent contempt authority to, when people are preventing it, obstructing the court's function, the court can, impose contempt, either civil or criminal, to get people to behave. And here's how it's explained again. As thus seen the power of these courts, and the punishment of these contempts can only be exercised to either one, ensure order and decorum in their presence, to secure faithfulness of the part of their officers, and to enforce obedience to their lawful orders, judgments, and processes. So this is again where I think Flynn might be in violation of the inherent authority of the court if he lied under oath. So what is Judge Sullivan thinking about? Like, why would he suspect that there might be perjury? Well, again, the issue for Flynn is that this isn't when he had to withdraw his plea and he pled guilty twice before, one in a pretty lengthy colloquy with Judge Sullivan. So here's the trial transcript before Judge Sullivan. This is back on December 18th of really, I was actually at this hearing, December 18th, 2018. And, there was this whole colloquy that Sullivan had with General Flynn. I'm going to zoom out slightly. Because the briefing concerned the court as he raised issues that called into question the guilty plea. This was the fact that he was raising the fact that, like, the FBI agents thought he was being honest. Like, that calls into question whether or not he was admitting to knowingly lying. And so Judge Sullivan went through this whole colloquy where he's like, any more false answers will get you in trouble. Do you understand that, Flynn? Yes. You have, and then stuff like, do you wish to challenge the circumstances under which you're interviewed? No, Your Honor. Do you understand you're giving up your right to challenge the circumstances under which you're interviewed? Yes, Your Honor. And there's other stuff in here, but it's a whole long thing. Are you satisfied with the services provided by your attorneys? Do you feel you were competent and capable of entering into a guilty plea? Do you understand the nature of the charges against you and the consequences of pleading guilty? Do you still want to plead guilty? Are you continuing to accept responsibility for your false statements? I am. So there's a question about whether or not there's a false statement here. I don't actually know the answer to that. It looks pretty clear that the mere fact of having pled guilty can't be used against you in a perjury prosecution. But it seems like statements you make while you're pleading guilty can be used against you. So if there's if Sullivan thinks one of these statements is false, he could be trying to push a perjury charge. There's some big issues here that I think that Judge Sullivan would be why Judge Sullivan would be going wild if he were doing this. One, there's first the obvious. If he wants to do this, he has to resolve the whole ineffective assistance of counsel issue that Sidney Powell raised. Right, while he was pleading to this, he was being represented by counsel who had a profound conflict of interest. I discussed this a couple weeks ago in a Periscope, but basically, because Flynn was potentially going to be charged with violating the Foreign Agents Registration Act, FARA, and Covington and Burling, his lawyers, had helped him prepare the registration statement, and the idea being that because that statement was now suddenly the subject of a criminal probe, right, whether or not there were false statements in it, there's a fundamental tension between Flynn and his lawyers, because Flynn, on the one hand, wants to say, I didn't do anything wrong, it's the lawyers who screwed up. And the lawyers have an interest themselves in saying, no, Flynn lied to us. We did our perfect legal work. We don't want to be either, negligent for malpractice because we screwed up Flynn's legal work, or potentially even involved in the criminal conspiracy to make a false statement. So from there was that intendable conflict. It's called an underlying work conflict. And those are the lawyers who's representing Flynn while he's pleading guilty here. So the court have to resolve that ineffective assistance of counsel to see whether or not what Flynn was saying here was knowing and willful under the circumstances. And I mean, they have to resolve that. They'd have to resolve, a whole bunch of other things about was Flynn coerced? Did these Brady violations implicate what Flynn was doing, and whether he was willing to say, how do the Brady violations implicate whether or not some guy is perjuring himself when he's pleading guilty and trying to avoid doing anything to stop the guilty plea? I don't know the answers to these questions. There are two big questions that I have. There are 3 or 4 actually, a slew of them. I don't have answers for you guys. One, whether perjury constitutes a contempt. I think it probably does, but I can't tell for sure, and I haven't found any authority that is directly on point. So I don't know the answer to that question. Whether or not there's actual perjury here, that would require a very detailed review of the transcripts of Flynn's plea, and then compare that to things like Flynn's declaration that he made when he withdrew his guilty plea, which is this document, right? Where he says on December 1st, reiterated on December 18, 2018, I pled guilty. I am innocent of this crime. Request to withdraw my plea. So, there might be tension there. And then, even if there is some inconsistency, does that constitute perjury? And then what about the defenses? What about things like ineffective assistance of counsel during the plea, the Brady violations? How do those relate to the question of these perjury questions? I don't know the answer to that either. So really, it's up in the air now. I think that what Judge Sullivan's doing here is really obnoxious. In sort of the abstract, a guy trying to withdraw their plea is trying to it's clearly saying I didn't do this, and I was feel quite coerced by the legal system into being forced to plea due to the threats made against my son. When you're telling that guy oh, we're going to get you for perjury because you lied while being coerced, or you lied while being represented by ineffectively, that's some screwed up nonsense. So I don't know how okay with that I am. But anyway, so that's what I think is going. That's just kind of explaining what's going on, right? We've gone through the whole thing. Who is John Gleeson? What is the point of this amicus curiae? What does it mean that he cited these cases? I think basically, from my opinion, the fact that he cited these cases, I think Judge Sullivan believes he obviously has authority to appoint an amicus. That's the Gin case. But I think he's also very skeptical of the notion that he has the authority to dismiss or to refuse the government's motion to dismiss, because he cited the Fokker Services case, which is incredibly on point. But that's also kind of why I think he's looking at this contempt charge, because he's I don't think I can, I don't think I have the authority to refuse the government's motion to dismiss, but I think I have inherent authority to prosecute a contempt of court, and I think Flynn perjured himself. So I'd like to see briefing on that question. And the reason he's doing that is because, like every other apparently member of the liberal legal establishment, he is apparently infected with Trump derangement syndrome. I mean, the number of liberal lawyers who I've seen be very, very aggressive about criminal justice abuses suddenly flip on a dime and decide, oh my God, like it's so terrible that Flynn is going to be exonerated. It blows my mind. Like, I don't know how, there's a one prosecutor, Paul Butler, former prosecutor, who's my former law professor in criminal procedure. He's a guy who's argued for racially based jury nullification. This is he's very woke. And for him to turn around and talk about like the importance of upholding the rule of law, like it doesn't jive. It doesn't make sense to me. So that, there's a lot of problems there. Anyway, so I want to quickly, let's take a look at Twitter. What's happening on Twitter in terms of the Flynn contempt? I want to kind of see what's new. Jonathan Turley says that Judge Sullivan has now appointed a retired judge to look into whether the court should issue an order to show cause. The court is not only considering denying a motion for dismissal, but considering a new charge. And this is, I think, a really important point. Like, considering the implications for many cases where defendants seek to withdraw their pleas due to prosecutorial abuse, it would create a threat of a judicial charge even when prosecutors agree with the defendants. That is a really big problem with the way Judge Sullivan's approaching this, right? Like, there are going to be cases where somebody wants to withdraw a plea or somebody pled guilty under coercion. And the idea that you're going to, like, go after them for perjury under those circumstances is really, really sketchy. So I mean, Shirley says Judge Sullivan was previously criticized for suggesting that Flynn could be charged with treason. He's now allowing third parties to make arguments in a criminal case on an unopposed motion. In addition, he's exploring a charge he may be able to make against Flynn. These are, as Shirley says, these are very discomforting. It's very, very sketchy. Like, here's the thing, like, I don't know, I think he has the authority to appoint an amicus, but the overall pattern of behavior is, like, extraordinarily biased against Flynn. Like, he's not talking about an amicus curiae to look at whether or not Brandon Van Grack has committed Brady violations, which he almost certainly has. He's not looking at a variety of other things. Instead, he's going fully with a liberal legal establishment line that says that, like, this is a horrible miscarriage of justice, it's totally ridiculous, and I want to throw Flynn in jail anyway. Somebody says, there comes a point where the court appears too invested in the punishment of the defendant and too active in creating alternatives to dismissal. I agree. I think that that's what's happening here. I think that, a lot of these moves are going to be very, very, there's probably going to be there might be mandamus, and certainly they're skeptical. They're very, very, I think they'd be very weak on appeal. I think Jonathan Turley's got it right. Let's refresh this. Hold on. So we had, the Technify put it out there. Let's see what anybody else is saying. Kyle Griffin, just reporting the news. So it's Breitbart. As Leslie Nakagu Gordon says, it's stunning. I'm pretty stunned by this news as well. So let's see. Anything else interesting? Yeah, right. All those crocodile tears from Democrats about the rule of law and criminal justice reform, they're trying to punish a defendant for changing his plea and being let it go. And I think Pollack has it right. It's no longer a trial, it's an acquisition. So that's pretty good. And hey, look at me. There I am. How about that? Thanks for watching, guys. Hope you enjoyed it. Again, reminder, if you are new here, hit the subscribe button if you enjoy the content. We are always looking to add more content, add more videos, and it really does help us. Thank you so much.